Hello, good morning to you all. We are very happy to be here at CNEL with the University of Rome, Università Cattolica, in managing this interesting workshop online and in presence. The matter that we will face with today is defined by our title, Outlining a Path for Responsible and Inclusive AI in the EU and in US. AI, digital market services, data, and law. As you can easily understand, we are dealing with one of the most important matters that European Union and the US are facing with, the balancing between innovation and regulation. We all know that there is a motto in Brussels: America leads in innovation, Europe will lead in regulation. But that does not work when successful regulation requires cutting-edge technical expertise that the EU has been lacking. That is why America, home of the tech engineers who are designing platform, AI, robots, must lead in creating policies for, let's say, guardrails in a digital world it is largely creating in the West. This point that could be, you know, a sort of principle focusing, mainly focused matter of our discussing will be part of the analysis that we will carry out this morning with the help of two worldwide experts, academic experts, scholars, well recognized, 𝗏𝗂𝗫 of the University of California, Berkeley, and 𝗏𝗂𝗫𝗃 of the European University Institute of Fiesole. We will have also a roundtable with three experts concerning let's say, the analysis between cost and benefits of what we call the fair balancing between regulation and innovation. 𝗃𝐢𝐠𝐢𝐭𝐚𝐥, advisor for artificial intelligence of the European Commission, Eleonora Faina, Confindustria, Anitec-Assinform, and Stefan Grand, senior advisor for artificial intelligence at the European Trade Unions Confederation. The conclusions will be assigned to 𝗦𝗫𝗶 his𝗶 for a sort of wrap-up exercise, and will be very interesting to understand the, let's say, the guidelines that we can pull out from this experience of this morning. For the introduction to our workshop, I'm very happy to ask my colleague and friend 𝗃𝐸𝐠𝐢𝐭𝐬, professor of the Roma Trade University and one of the council here at CNEL, to let us better understand where we are, what we are going to do at European level concerning artificial intelligence. We have limited time. Just to give you an idea, we would like to give you all the right time for the explanation of your viewpoint, but this is also an exercise to let we can exchange ideas. So more or less we will remain in speech of 10 minutes for the roundtable, 20 minutes for the keynote speech. Please, Silvia, the floor is yours. Thank you again for your introduction.
Grazie innanzitutto al collega Michele Faioli per aver promosso questo importante appuntamento e per aver invitato tanti ospiti così importanti con i quali confrontarci. Io in realtà mi limiterò a fare dei saluti più che un'introduzione. Porto i saluti sicuramente del presidente 𝗏𝗏𝗃, che non può essere oggi presente al CNEL, e i miei personali. Da molto tempo al CNEL approfondiamo il tema dell'innovazione tecnologica e della trasformazione digitale nelle sfide che pone in particolare sul piano sociale, dell'impatto sociale. Siamo convinti che l'innovazione tecnologica non ponga soltanto rischi, ma anche opportunità per le persone, per i cittadini, per i lavoratori. E questo è una evoluzione, potremmo dire, ineludibile con il quale tutti dobbiamo fare i conti, il business, la pubblica amministrazione, i privati, i regolatori. Oggi in particolare affrontiamo il tema del rapporto tra regolazione e innovazione, in particolare l'intelligenza artificiale. Ringrazio Michele Faioli per aver posto oggi una questione, la prospettiva sovranazionale. Molto spesso noi siamo abituati a ragionare di queste innovazioni nell'ambito dell'ordinamento nazionale, ordinamento giuridico nazionale, al massimo europeo, sul quale adesso dirò alcune parole. Ma sicuramente il nostro ambito geografico di riferimento ormai è quello mondiale e non solo europeo. E quindi c'è un tema anche di confronto tra le tecniche di regolazione e i diritti che nell'intelligenza artificiale trovano riconoscimento non solo in Europa, ma sicuramente negli Stati Uniti e anche in altre grandi zone geopolitiche del mondo. Quindi il primo tema sul quale mi piacerebbe appunto che oggi ci soffermassimo è quello del livello di regolazione. A quale livello di regolazione o a quali livelli di regolazione dobbiamo affrontare il tema del rapporto tra intelligenza artificiale e diritti delle persone. Come sappiamo, in Europa ci stiamo muovendo. Abbiamo capito che il tema dell'intelligenza artificiale e della trasformazione digitale è un tema innanzitutto europeo, che va affrontato a livello europeo e impone una omogeneità di regole, ma direi ancora prima di policy. E qui i temi sono tanti e non li possiamo affrontare. Il tema della autonomia tecnologica dell'Europa e della sua dipendenza dall'esterno o da altri grandi player mondiali, il tema della individuazione di diritti minimi comuni a tutti i paesi, cosa che non è semplice in linea generale e ancor meno in un ambito così nuovo, dove in realtà l'individuazione di diritti fondamentali già di per sé è un problema, una sfida. Quali sono i diritti fondamentali da proteggere nello sviluppo dell'intelligenza artificiale? Quali di questi possono trovare una realizzazione a livello europeo? Quali di questi devono essere affrontati e gestiti dai legislatori nazionali? Quindi il tema è quello del livello di regolazione. Un secondo tema è la tecnica di regolazione. Che tecniche di regolazione per l'affermazione dei nuovi diritti dobbiamo scegliere? L'hard law, la soft law, sistemi che puntano sull'accountability, sistemi che puntano sull'affermazione di nuovi diritti, il diritto alla trasparenza, il diritto alla revisione della decisione algoritmica, il diritto all'informazione. E quindi queste sono tematiche nuove. E poi il rapporto, direi un altro tema fondamentale, è quello del ruolo dell'attore pubblico e degli attori privati in questa materia. C'è un grande attivismo dei privati, rischiamo che la gestione dei rischi e quindi anche dei nuovi diritti sia rimessa a pratiche o anche al business e quindi a dei driver che sono quelli del mercato essenzialmente e dei profitti dei grandi player internazionali. Invece dobbiamo capire, e questo ovviamente è un processo che non può essere ostacolato, però in questo dobbiamo capire il ruolo essenziale che l'attore pubblico deve rivestire in questo contesto. Quale ruolo può ritagliare il soggetto pubblico anche rispetto, per esempio, alla gestione delle infrastrutture e quindi anche delle infrastrutture tecnologiche attraverso le quali possono essere esercitati i diritti o, diciamo così, messi in atto i nuovi scenari dell'intelligenza artificiale. Io più di questo non andrei. Allora, sulla questione penso che oggi si parlerà molto dell'AI Act, quindi della regolazione o della proposta di regolazione, almeno a livello europeo, è stata avanzata sull'intelligenza artificiale. Rispetto a questa, diciamo che l'Europa sembra adottare una tecnica di regolazione basata sulla classificazione del rischio, innanzitutto, dell'intelligenza artificiale, delle diverse applicazioni dell'intelligenza artificiale, e quindi un approccio basato sul livello di rischio, sul tasso di rischio, un approccio basato sulla responsabilizzazione del produttore dell'intelligenza artificiale. Questo può porre alcuni interrogativi sulla diffusione di un sistema di responsabilità anche su altri soggetti, non solo sui produttori dell'intelligenza artificiale. E poi è una regolazione che tende a, più che armonizzare, mi sembra, uniformare le legislazioni nazionali, cioè dettare una regola uniforme più che puntare all'armonizzazione delle regole. Questo probabilmente è una scelta inevitabile, cioè l'adozione di regole unitarie, uniformi e non soltanto convergenti, però è anche vero che, come tutti gli strumenti che vogliono regolare in modo uniforme, si pongono delle problematiche di compatibilità con gli ordinamenti nazionali e anche con strutture legali preesistenti con cui bisogna fare i conti. Io non vado oltre, ringrazio ancora Michele Faioli per questa occasione, cedo a lui la parola e la conduzione dell'incontro di oggi, ascolterò con grande attenzione. Mi scuso di aver parlato in italiano, ma non sarei stata in grado di dire le stesse cose in inglese. Grazie.
Grazie Silvia, thank you very much for your introduction. In our view, it's great to bring the US and EU approach together today. You know, Rome in a certain sense could be considered a geographical middle between the two. And we are happy that we can begin this discussion with Sonia and Nicola. And we are going, what we are going to do today is to really take you through the complex and comprehensive piece of legislation that at European level is going to be enacted to make it easier for you to understand the EU approach and the US approach. I began some years ago to study this matter on the basis of a European grant as a labor law scholar, and I considered that there are three main areas in which AI will give rise to new challenges to scholars in general, to the societies and so on. To me, there are three areas, and these three areas are in this EU pact concerning AI. Let's think about AI regulation, EU platform directive proposal, data governance regulation, Digital Service Act, and Digital Market Act. The three areas are, to me, responsibility. If AI were to cause harm or to create something beneficial, which should be held responsible? Rights, the second. Are there moral or pragmatical grounds for granting AI legal protection and responsibilities? The third is powers. How should AI make important choices that, and are there any decisions it should not be allowed to take? Now, the following keynote speech will expand also these themes, demonstrating the types of problems that are likely to arise and how they may be addressed by current legal system in EU and in US. Let's begin with Sonia Key𝐤𝐠𝐢𝐭𝐚𝐥. She is professor of Berkeley Law School. Her research is focused on intersection between technology, intellectual property, civil rights, in particular anti-discrimination, privacy, freedom of speech. Professor Key𝐤𝐠𝐢𝐭𝐚𝐥 current project focus on the trademark law, branding and advertising, artificial intelligence, the intersection between the right to information and human rights. During the Obama administration, Professor Key𝐤𝐤𝐿 was selected by US Commerce Secretary Penny Pritzker to be part of the inaugural US Commerce Department Digital Economy Board of Advisors. Please, Professor Key𝐤𝐤𝐿, thank you again. Take the floor. Thank you very much to be here with us.
Oh, thank you so much. It's really an honor to be in conversation with so many distinguished folks who have been working on these issues. So I'm really excited to have this conversation. Let me just go back. Okay, perfect. Hi, everyone. It's really lovely to be here. So I'm going to give a talk about two themes that I think really categorize or at least characterize our period where we're thinking about how to deploy artificial intelligence. The focus of my talk is really on how to think about artificial intelligence from an anti-discrimination perspective. And I want to start by just pointing out a quote that I think is really significant, which is from Andrew Ng, who has worked for Google and has designed some of these systems, who says, just as electricity transformed almost everything 100 years ago, today, I actually have a hard time thinking of an industry that I don't think will transform in the next 100 years. And when we think of every industry, fintech, logistics, healthcare, security, agriculture, transportation, everything is going to be revolutionized by the deployment of AI. And what this does is it opens up a host of questions for those of us who are really interested in the intersection between law and the marketplace. And these questions really circulate on questions of prediction, risk assessment, research, legal decision-making. All of these kinds of areas will be transformed by AI. And the purpose of my talk is really to think about some of the risks of this. And so just as algorithms determine the optimal way to kind of produce and ship goods, the prices that we pay for those goods, the money that we borrow, the people who teach our children, the books, the articles we read, every activity can now be reduced to an actuarial risk or score. So one author has said, if every algorithm suddenly stopped working, Pedro Domingos has written, it would be the end of the world as we know it. And so the rise of AI decision-making, I think, poses a similar kind of challenge to democracy and democracy's basic framework. And so one of the things that I've been thinking about a lot is how the rise of these trends towards privatization, trends towards prediction, and trends towards automation in AI have really posed similar kinds of risks to minorities. And so I would argue that a lot of these questions about representation, questions about truth, questions about justice, are going to be driven increasingly in the next few years by an underlying dependency that is starting and that is really flourishing on artificial intelligence. And this extends to everything, the lives of individuals, the lives of minority populations, and all of us. But our dependence on AI doesn't come without significant questions about social welfare concerns. So in 2016, which seems so long ago, there was a revelation in the United States that Facebook used algorithms to determine users' ethnic affinity, which could really only be understood as a euphemism for race. And the categories then allowed advertisers to exclude certain groups and certain ethnic affinities from using their ads. And so after initially defending these categories as kind of positive tools that allowed users to see more relevant ads, Facebook eventually realized that they were subject to a tremendous degree of legal liability in the United States, and then they removed these categories for the areas of housing, credit, and employment, all areas protected by law 3 months later. And what they realized was that their desire to kind of generate more choices for the advertiser also meant that advertisers could actually discriminate against certain groups. But Facebook, even though it took a step towards anti-discrimination in this case, it continued to raise issues of discrimination later. So in September of 2018, in the United States, the American Civil Liberties Union filed a charge against Facebook, contending that another of its tools violated the same set of laws by enabling employers to target only men to apply for a wide variety of jobs, which included roofing, driving, and other opportunities. And the plaintiffs who came forward in this case were women-identified job seekers who used Facebook in order to receive information about job ads and other recruitment opportunities. But as their lawyer explained, they never saw these opportunities. They never received the ads because they were not targeted by the advertisers. So as one plaintiff in the case said, you don't know as a Facebook user what you're not seeing. And what you're not seeing is often a function of what population group you have been classified by Facebook in accordance with gender, race, ethnicity, and so on. And this question of how one becomes categorized and how one is identified is really something that extends as well to politics. So even aside from the allegations of facilitating employment discrimination, Facebook was also rocked by the allegations from a whistleblower, 𝗏𝗶𝘃, previously at a firm called Cambridge Analytica, who came up with the idea to harvest millions of Facebook profiles and then target users with political ads that would mesh with their psychological profile. So since advertisers tend to show users content that affirms their existing interests and beliefs, within these kinds of filter bubbles, fake news began to flourish and potentially affected the results of the 2016 US election. And those are some older examples, but for the most part, these reports are really just the tip of the iceberg regarding the potential impact of algorithmic bias on today's society. And there is a deeper parallel between civil rights and artificial intelligence that is also worth noting. So if information choices are driven by private preferences, then AI enables us to make even greater choices on a macro level about how entire demographics can be affected by AI. So what does this mean in terms of the relationship between AI and injustice? Well, in this talk, I want to suggest that AI has created a crisis for the consumer, right? Consumer welfare is something that I know many of us have thought about today, particularly 𝗏𝗏𝗏𝗏's work. And second, that AI has created an unparalleled set of opportunities as well for advertisers. So this is an age of both commercial and political information, as well as political and commercial disinformation. As I would argue in the United States, one of the big complicating problems is how our fundamental rights of privacy, due process, and equal protection can address these issues. But before we get there, I want to talk about the roots of AI. So a number of years ago, a leading law professor in the United States by the name of Lawrence Lessig said something extraordinary. And what he said was, code is law. And these three words, I think, went on to predict many things about the relationship between law and technology. But most important, what it did was it taught lawyers like myself, right, and 𝗏𝗏𝗏𝗏, other lawyers and professors and economists as well, that essentially whatever we were doing, whatever we were writing, whatever we were thinking about was essentially irrelevant in the face of technology. That really our biggest source of regulation was not law and not lofty constitutional principle, but rather source code and object code and what they did to define or to regulate human behavior. So I teach at University of California at Berkeley, as has been mentioned in the law school. And one of the things that we do with our students is often throw out hypotheticals for our students to respond to and think about. So I want to tell you kind of 3 different stories about how AI has been deployed in the United States. And the first story that I want to lay out for you is the story of 𝗂𝐿𝐵. He was a college student and he applied for a job in a grocery store. And he was subject to a personality test. And this personality test was a very detailed test, and it tested for things like sociability and extroversion. Are you outgoing? And in this process, this test also touched on a variety of mental disorders. And Kyle applied actually for several jobs. He applied for 7 in total, but in each one of them, he was asked to take the same exact test. And it was offered by a company that specializes in AI-related hiring software. And he had a friend who worked at one of the companies, and he told him that the reason he didn't get any of the 7 jobs he applied for was because he had failed the test. And why did he fail the test? He failed the test because he was actually undergoing treatment for mental health issues. And the type of mental health issues that he was facing also touched on the questions of extroversion and sociability. And so his father happened to be a lawyer and filed a complaint arguing that the test violated the Americans with Disabilities Act. And so eventually they reached a settlement and the test was retired. But it turns out that the test was also pretty inaccurate. The data shows us that these personality tests don't actually correlate with great employees, but companies still use these tests as ways to weed out applicants. And the result has a disparate impact on people like Kyle. And the second story that I want to tell you is a story that's a little bit broader, and it involves AI-related tools in the criminal justice system in the United States. So across the country in the United States, courts use profile-based risk assessment tools, and they use these tools to make decisions about pretrial detention, and they try to predict who is likely to commit future crimes. And the tools are based on aggregated data about past defendants. But the problem is that the data classification software, in order to train itself, relies on training data that actually, curiously, often reinforces the very policies that lead to imprisonment and mass incarceration in the first place. So in one study, these risk assessment tools, they require defendants to answer over 130 questions. But it turns out that the algorithm is also not accurate. In fact, it has significant issues of racial injustice. It was particularly likely, one study reports, particularly likely to flag Black defendants as future criminals, wrongly labeling them this way at almost twice the rate of white defendants. And there are also predictive policing algorithms which help to, which predict or purport to predict areas of future crimes. But because those predictions are based on areas where there's more police, right, and more surveillance, the more crime gets reported as a result. So again, the data is skewed in a way that could be inaccurate, and more resources tend to go to those areas. And then what you see is kind of a self-reinforcing mechanism that simply predicts more crime in areas where there's more surveillance. And this has a racially disparate impact on racial minorities as a result. And the third story that I want to tell you is the story of Tammy Dobbs, who is a woman from Arkansas, and she has cerebral palsy, and she requires caregiver assistance from the state. So when a qualified nurse, a human being, was used to determine how much care she needed, she got 56 hours of care a month. But when a proprietary algorithm was used for automated decision-making, her care dropped by almost half. So she was only given 32 hours of assistance and care. And this happened to her without any opportunity for review, comment, or reassessment. And this story is replicated in many other examples where a number of individuals who receive social services have reported their services being dramatically reduced, where automated decisions are used without any transparency and without any explanation. So each of these narratives, I think, offer us examples of what happens to real people in the context of machine learning. And they offer us ways to humanize the data points that many of us are used to scrutinizing on an aggregated basis. So in the first story, we have a story of discrimination by a private employer that legally violates the rule that requires us not to treat people with disabilities differently. And in the second story, we have a story about discrimination by a private entity that has signed contracts with the federal government and with state governments and makes predictions that are often incorrect and racially biased. And in the third story, we have a story of discrimination by a public agency, a social services agency that figures out that it can use AI to deny benefits from otherwise deserving populations. And so in each of these stories, we see some form of injustice. And so I would encourage us to think about AI broadly, not to just think about AI broadly, but to think about it into three categories of potential injustice. So you have injustice in the data, the training data, you have injustice in perhaps the design of the algorithm, and then you have injustice in the outcome, in the decision that has been reached. And so more specifically, in each of the results that are reached here, we often see an answer that fails to take into account nuance and complexity when it comes to the human subject. So lawyers are supposed to be really good, right, at figuring out how to remedy forms of injustice. But what we see here are stories that actually violate legal protections, like equal protection obligations under law, right, which require us which requires us not to treat people differently on account of race, gender, disability, nationality, and other categories. But in the criminal context, we also see a context where defendants are supposed to have constitutional rights to see the evidence against them. And in the context of social services, the third story I told you, you're supposed to have due process of law that explains why an automated decision-making system reached certain results. So as we see, Lawrence Lessig was correct. We are poised at this moment with our data and our processing skills and our AI-related tools to produce a world where code becomes law. And code often is able to wreak havoc over these legal principles about due process, equal protection, criminal justice. Now, as I've suggested, big data often and always has promised significant benefits to the economy. It allows consumers to sort and find products more quickly, which economists would say lowers search costs, but their potential to shape society in dramatic and unanticipated ways, I think, has often been underestimated. So errors at any stage of data collection can become amplified in the next stage. And what this does is it produces outcomes that are often deviant from the story of human complexity that I'm telling you. They produce outcomes that can be troubling and often very difficult to detect. And since these models often reflect the design choices of the humans that built them, they often carry the bias of the person that designed these algorithms. So while most researchers focus on the dangers of false positives and false negatives in data, far more pernicious types of discrimination can result from how classes of data are defined and the sorts of examples and rules that algorithms learn from such data. So bad data can perpetuate inequalities through machine learning. And this leads to a feedback loop that often replicates existing forms of bias, potentially impacting minorities as a result. So for example, the first international beauty contest that was derived from AI sparked controversy after the results of its 6,000 entries from over 100 countries revealed that of the 44 winners of this contest, the AI system determined that of the 44 winners, right, it turned out that almost all of them were white, right? And why is that? Well, there are probably a host of reasons, but one of the most dominating reasons for why was because the training data that was used ostensibly to establish classifications and standards of attractiveness among humans probably did not include enough people of color, right? And this creates a risk of disinformation. And this is actually similar, I would argue, to the kinds of disinformation campaigns that we've seen in election-related discussions. But it's a kind of disinformation that comes not from an intention to discriminate, but from bad data or bad algorithmic design. So it turns out that most analysts have found that data often fails in the United States to include marginalized communities. And in the US, we're talking about African-American populations, Latinx populations, Native American populations, people of a lower socioeconomic status, LGBTQ individuals, and immigrants. Not only are these people disproportionately missing from sources like internet history, social media, and credit card usage, but they're often missing from electronic health records and genomic databases. And so in turn, the effects of this absence can create misrepresentation that winds up affecting different groups. So if machine learning model is trained on data that is biased in some way, then in decisions that are derived from that data can systematically disadvantage individuals who happen to be over or underrepresented in the data set. And this feeds into disinformation. So one author, Cathy O'Neill, has suggested that our algorithms have a particularly disparate impact on the poor because wealthier individuals are more likely to benefit from personal input. The privileged, she writes, are processed more by people, the masses by machines. And the absence of privacy protections in the United States actually creates an even greater problem. So for example, one study in the United States found that over 80,000 health-related web pages shared found that over 90% of those sites, 90% of those 80,000 sites shared user information, which was highly sensitive with outside third parties. And so these applications of data analytics require us to think more broadly about how to address inequality and discrimination in a digital age. But there is another and kind of deeper reason for why this age of machine learning is so transformative. And that, I would argue, is because it requires us to evaluate our entire spectrum of civil rights in the process. So like the civil rights era that came before it, AI is implicated within a vast array of decisions that come not from the government, but from the private sector. And so the right to be considered for employment, the right to be free from consideration of one's disability, this correlates to the right to work, the right to an education, the right to vote, the right to make contracts, the right to travel, the right to get insurance, the right to receive information. All of these are questions that are at issue when an algorithm makes private decisions about who does and who does not receive the entitlement. And the problem in the United States is not just that governmental decision-making has been delegated to private parties that design code. It's the reverse situation, where private entities have significant power and it essentially is unregulated by the US government. And so what this requires us to ask ourselves is this fundamental question. Do we need to redesign the algorithm? Or do we need to redesign civil rights law to address the algorithm? And each approach requires very different kinds of solutions. So in the Obama era, then President Barack Obama proposed the Consumer Privacy Bill of Rights that would allow consumers to challenge and correct data about questions about credit or insurance. But nothing happened with that proposal. There are other things that are happening in the United States, but I would argue, as we spoke about, as I was speaking about with Mikhail earlier, there are many ways in which the United States, I think, is quite behind the EU. But here are some of the things that are happening. The Algorithmic Accountability Act requires the use of impact statements for large companies that process sensitive information. There's another act called the Justice in Forensic Algorithms Act, which limits the extension of trade secret privileges to ensure that defendants have access to source code. There are proposals at the FTC Commission to address issues of AI-related discrimination and data misuse. There are discussions now, finally, after so many years, of potentially having a national privacy law. The National Institute for Standards and Technology has started to build a system that outlines different kinds of AI risk management frameworks. But I would say that these are limited, right? Even this framework that I just spoke about is intended for voluntary use. And the idea is to sort of improve trustworthiness, not necessarily directly address discrimination. In New York and Washington State, there have been proposals to add more transparency to automated decision-making. But again, these are really limited by the fact that we do not have national privacy standards. And so this leads us to the question, before we open up the discussion, I want to kind of lead us to a couple of things to think about that focus on kind of the rights of the consumer, since I know the issue of consumer welfare is something that we've thought about, many of us who are speaking today have thought about. And these questions, I think, really raise how we remedy these kinds of issues. How do we remedy these issues? Are these legal questions, right? So is a right to an explanation sufficient, due process? Or do we need something greater? Do we need something more fundamental, like a right to privacy in the United States, or even a right to equal treatment from private companies? Or do we need a right to transparency or accountability? And the last thing that I kind of want to leave you with is a theme that is very popular in the United States in terms of what law students learn, right? And every lawyer who enters law school in the United States is taught about this theory founded by someone named John Hart Ely, who wrote a book called Democracy and Distrust. And his theory was basically the idea that you always want to have judicial review and courts in place, because you never want to create a system where the will of the majority can trample over the rights of minorities. And I would argue that the very same question is really at the heart of what we're struggling with here. We have, through AI, empowered the majority through machine learning to have decision-making power over the rights of minorities who are outliers from data, the ones who need enfranchisement the most. And there is this central tension that we just spoke about, which 𝗏𝗫 spoke about in just a few moments ago, between kind of efficiency, right, and innovation, which AI and automated decision-making systems certainly provide. But there is a trade-off between that and inequality. And if we fail to fix this problem, we risk allowing code to become law, and many more injustices, public and private ones. We open the door to that from artificial intelligence. And so as we think here today about the linkage between discrimination, inclusion, and AI, I would also really encourage us to think about the lens of the consumer, right, as part of a central part of this enterprise. Because to me, and to many of us here today, the future of a well-functioning democracy and a well-functioning marketplace depends on it. So thank you so much. I look forward to the discussion.
Thank you very much, Professor Ǩē𝐤𝐿. So the question is when and to what extent to intervene. So regulators cannot intervene too early, too much, nor too late, an extremely challenging tightrope work. Many regulatory issues raise the question on when and what, or to what extent the regulators can intervene if they want to regulate. I want to point out and to leave the floor to Professor Nicolas Petit, an intrinsic dilemma in technology regulation. Controlling technology is difficult in its early stage because not enough is known of its possible or probable effects. And it is also difficult once the technology is well developed, because by then intervention is expensive, drastic, or impossible, because the technology cannot be reversed. So we should find a balance. We should balancing the two different interests. We should try to find the way to have on one side the market structure sectors and the natural forces of the market. On the other side, we should also protect the rights of the individuals, of the workers or minorities, and so on. What we are going to understand now with the keynote speech of Professor Nicolas Petit is where we are at European level. Professor Petit is an academic specializing in competition policy, economic regulation, law, and technology. He holds the chair in competition law at the European University Institute in Florence, Fiesole, Department of Law, and the Robert Schuman Center for Advanced Studies. From 2018-2020, Professor Petit has been a member of the European Commission High-Level Expert Group on Artificial Intelligence. Please, Professor Petit, thank you very much again for joining us, and take the floor.
Thank you, Michele. Can you hear me?
Yeah, very good. Thank you very much.
All right, that's great. Okay, so I want to start by saying Professor Fiesole and 𝗏𝗏, as well as Salvatore Santoro, for the very kind invitation to the workshop. I'm sorry I cannot be in presence with you today. My wife had to leave to Brussels for urgent business matters, and I had to bring my daughters this morning to daycare. It would have been a stretch to join you in Rome this morning. All right, so about a year ago, on 21st April 2021, the EU released its widely anticipated AI Act, or the draft AI Act. And the Act, according to European Commission officials, plans to introduce the first comprehensive draft regulatory framework for AI in the EU. And for the time being, on a global level, the word choice of act, not regulation, an Anglo-American term, betrays a clear ambition to set a world standard. Now, what's probably more important is that the AI Act wants to achieve, and that will resonate with my predecessor's speech, wants to achieve three goals, namely secure, trustworthy, and ethical artificial intelligence. So the question that I want to address today is, can the AI Act achieve these goals? And my talk will be based on a paper that I'm developing with my colleague here at the UI, 𝗏𝗏𝐼𝐵. All right. So the central points that we are trying to make in the paper, and that I'm going to try to push in the talk here, is that the EU prefers to follow well-trodden path. Three path-dependent regulation approaches, regimes, and goals combined to give the AI Act: the risk-based philosophy, the product safety method, and the fundamental rights ambition. The weaving together of these three approaches gives rise to three challenges that I call the challenge of method, the challenge of goals, and the challenge of capabilities. And I'm going to run you in a few minutes through these various goals. Okay, but let's start with starters. So the AI Act lays down what we lawyers in the EU call market harmonization measures for AI systems. The idea that in all member states, uniform rules will apply to protect the three public interests of health, safety, and fundamental rights. A legal process of harmonization of the domestic rules, it is believed, will support the development, the marketing, and the use of AI systems in Europe. So providers of AI systems that will comply with the harmonized rules will be allowed to place a product on the market somewhere in Europe, and the product will be able to travel across the European Union. Okay, so the AI Act adopts a risk-based approach. It's a very expressly phrased in terms of this is a risk-based regulation. And in legal theory, many possibilities exist to implement a risk-based approach. Prohibition systems, approval systems, declaration systems, permission systems, notification systems, with all sorts of nuances. There's libraries of scholarship on these various approaches. Now, what's interesting here is that the AI Act chooses a triangle of options. So it's all about three in this talk. The the approaches to risk are to start a precautionary approach for certain types of AI systems which are deemed to create unacceptable risk, a product safety approach for high-risk AI systems, and a self-regulation approach for low-risk AI systems. Okay. Now, I want to concentrate here today on the product safety approach, which applies to high-risk AI systems, and the AI Act is really about high-risk AI systems, not so much about the other two categories. So, under the product safety approach, an high-risk AI system must comply with certain technical requirements which are defined. I'm going to be a bit technical here, which are defined in Article 9 to 15 of the AI Act before being placed on the market. Okay. And once the system is placed on the market, there's a requirement for providers to engage in what is called post-market monitoring measures. So the AI Act in that regard is very similar to other pieces of EU regulation, which basically establish rules that require compliance with essential requirements before placing on the market, and then a post-marketing system which requires some monitoring by the providers, the manufacturers, and by external organizations. Okay, so here what we have essentially is that the supplier of an AI system will have, before it places the product on the market, to basically comply with these obligations found in the AI Act and supplemented by a specification from standardization bodies, standard setting organizations. Once the provider will believe that the product complies, the provider can place the product on the market with a label and then engaged into post-marketing monitoring. In some cases, but in few cases only, there is a requirement to actually notify the products, the system, to an external organization for ex-ante verification. In most cases, especially for standalone product systems, standalone AI systems, which are not really related to the use of another product like a car or a toy, for all these standalone products, or for most of them, there is no requirement to have this verification by an external body. The provider can place the product on the market following a spontaneous compliance process. Okay. Now, enough with the technicalities, and let's maybe look into the various issues that arise from this approach. And again, I'm cutting corners. The AI Act is very complicated. It's very
maybe there is a problem with your slide. I don't know if you can scroll.
Yeah, I was just about to move them now. All right, so I want to talk now about the first challenge. So the challenge of method. So the choice of this product safety framework has a bunch of advantages. We can draw on experience with other pieces of EU regulation. We also can draw on existing institutions like standardization bodies or market surveillance authorities. So there is, in a way, some economies of scale and scope and learning involved into the selection of that particular method. But there is one, I believe, key challenge. The classification of an AI system as a high-risk device under the AI Act embeds a problematic assumption. The assumption is that it is possible to determine in advance a specific function or use case for AI systems, right? In a product safety framework, you often operate by examining risk in reference to a specific purpose, use case, or function of a system. And the problem, of course, is that a non-trivial amount of AI systems are general purpose tools or technologies, GPTs, without a specific function or use case. So the question that arises is straightforward. Are these general purpose technologies covered or not by the risk classification found in the AI Act? So I don't want to bore you for too long with what a GPT is, but economists tend to define GPTs as technologies which have three properties, three again. They can be used in many downstream sectors. they present inherent potential for technological improvements, and they bring about innovational complementarities. Textbook examples include the steam engine, electricity, or semiconductors, but you may also want to classify telephony, emails, and social networks as belonging to the category of general purpose technologies. Okay, so the idea that the AI Act would cover general purpose technologies, AI systems, is not without support if you read through the text. The recitals and the explanatory memorandum of the AI Act appear to be perfectly aware that some AI systems are GPTs. The sole explicit exclusion in the AI Act concerns AI systems used for military purposes. So had the AI Act been willing to exonerate GPTs from its scope, it could have done so by means of similar reference in that exclusion provision in the instrument. Last but not least, the definitions found in the AI Act lean towards support to the idea that both the case of GPTs AI systems, but also of specific purpose AI systems are covered, right? This is explained in the paper. I don't have time to go through that, but if you look linguistically at what the text says, there is support for this view that indeed the AI Act intends to submit GPTs to its obligations. Now, at the same time, some people in the public conversation have made the contrary arguments. That is that the applicability of the AI Act to GPTs is not a given. And in fact, the multiple references in the AI Act to the concept of intended purpose would in itself, by nature, put outside of the AI Act the concept of a GPT. A GPT, by definition, cannot have an intended purpose. So there's been a lot of pushback on this idea that the AI Act would apply to GPTs, in part because the text of the instrument is essentially based on this idea of intended purpose. You can see references to intended or specific purpose everywhere in the documents. Okay. All right, so I won't point you out to specific provisions in the instrument, but this debate exists, and it's not just a theoretical discussion. In the existing lawmaking conversation, so the instrument today is examined by the European Parliament. At the European Parliament, there has been a key and thorny conversation about the question of the inclusion of GPTs within the scope of the AI Act. Okay, so several options have been to date contemplated in the procedure, and all of them have pros and cons. So one explicit option for the lawmakers is to explicitly exclude GPTs from the text. The downside of this approach is that it will be hard to define in text what a GPT is. An alternative that has been proposed consists in considering that GPTs are indeed covered, but to allocate the burden of compliance on the deployer that will give a purpose to the GPT. For instance, the Slovenian presidency of the Council has proposed the inclusion of Article 52A, which would state that the deployer of a general purpose technology, the deployer that finalizes, that gives a very specific application to the general purpose technology, should not be actually the one with the burden of compliance, but rather than the provider of the general purpose technology should be the one with it, right? Okay, now, one last option is to consider that both the provider of the GPT and the deployer of the more specific declination of the GPT are covered by the instrument. But then if you have this system, you create a lot of uncertainty, and you might actually undermine some providers of GPTs more than others, in particular the open source community, for reasons that I can explain later if we have time for a chat. So none of these options is perfect, but there's a big question about, are GPTs covered? And in this case, who bears the burden of compliance with the requirements found from Article 9 to 15 in the AI Act? Okay, and these issues are real issues. Okay, I turn now to the second and the third challenges, and I'll be shorter. Okay, so the second challenge is the challenge of the goals. So the framework that the European Commission has proposed tries to protect three public interests: health, safety, and fundamental rights. Now, this is interesting. The AI Act is not the first piece of EU legislation that, of EU product safety legislation that assigns a fundamental rights goal to the instrument. But what is more interesting is that the AI Act, compared to other product safety instruments, is very, very extensive in terms of the obligations created in relation to the protection of fundamental rights. So to give you just a few examples, adverse impacts on fundamental rights may ground extensions of the list of high-risk AI applications that are found in the instruments in the annexes. Besides, risks towards fundamental rights might allow the Commission to actually adopt from its own motion common specifications that go beyond what standard setting organizations define. Right? So there's lots of things here. One last example is that the fundamental rights are mentioned as the regulatory goals in the technical provisions of the AI Acts, such as, for instance, the definition of the goals for human oversight. So there's a lot of obligations. So the point is this: there's lots of hard legal fundamental rights obligations at various points in the life cycle of AI systems, which are found in the instruments. Okay, so what does this mean? So it means this. It means that the AI Act has selected a fundamental rights goal and uses a product safety instrument to achieve it, right? So the approach of the European Union can be seen as this. It's basically, we want to protect fundamental rights, but rather than doing this through courts, we're going to do this through the product safety evaluation, assessments, and mitigation framework that is well in place in the European Union. Now, this point is not benign. This choice of approach is not devoid of consequences. And the point, to be extremely clear, is this: under a product safety lens, experts try to limit uncertainty over risk. And safety assessment in practice involves answering risk questions in a probabilistic, how much likelihood, structured, if likely, how severe, if severe, how detectable, exhaustive, if risk A is minimized, is there a risk B? If risk B is minimized, is there a risk C? And independent way. Absence of risk B doesn't mean that existence of risk A is unproblematic, right? Besides, risk experts have to define threshold values for acceptance of risk. Highly likely, moderately likely, in all likelihood will happen. So we have a method of risk mitigation here, which is extremely different from the method usually applied to the protection of fundamental rights. Fundamental rights protection is extremely different. Fundamental rights protection is not about commensurability. It's not about actuarial assessments. It's not about quantifying deviations from certain idealized and objective benchmarks. Fundamental rights protection is a science of trade-offs and qualitative assessments. So reliance on a framework of product safety may, in some cases, filter out some risks to fundamental right protection and sometimes filter in risks to fundamental right protections in ways which are extremely hard to predict. Okay, one other point which I think requires to be made very clearly is that these choices, and that allows me to go to my third challenge. These choices are required from institutions which might not be ideally placed to do them. So by turning product safety legislation into an instrument to pursue fundamental rights goal in a way which is maybe more intense than before under existing regulation, the EU is asking bodies known as standardization organizations or market surveillance authority to engage with very, very sophisticated detail in these trade-offs assessments that I mentioned before. Now, the EU has its own standardization organizations, CEN, CNEL, and 𝗡𝗂𝐸, which coexist with private standardization bodies like IEEE and ISO. And what matters is this: these standardization bodies are not really famous for the transparency of their procedures and of their outputs, and for good reason. We have standardization organizations that gather experts to develop technical solutions essentially to engineering and risk problems. And these organizations generally operate outside of the public conversation to avoid capture, to find, risk is something that you don't want to subject to any type of capture by public or private interest. You want planes to fly, that's all. And therefore, the culture of regulation that these entities have, which tends to be a little secretive or at least a little away from the scrutiny of the public, is not necessarily compatible with the dealing that is required from them by the AI Act, and especially dealing with these trade-offs, which are extremely complicated. Now, of course, you might object to this idea that courts, as was mentioned by my predecessor, are not necessarily very transparent either. I mean, there is a very well-known principle that the secret du délibéré, or the secrecy of deliberations of judges, is not something in which the public should partake. But the difference between courts and standard setting organizations is that the courts, sorry for this, is that the courts are used to engage in cross-cutting social, legal, political problems. Whereas standard setting organizations, and for good reason again, might not have traditionally developed the learning required to address non-technical issues like commercial problems, pricing issues, but also political problems, the issues of discrimination, representation, mobilization, minority rights protection, and so on and so forth. We know from the past that experiences with trying to expand the mandate of standard setting organizations have not gone well. IETF, a major international body for internet standardization, once proposed guidelines for incorporating human rights considerations into technical standards. The proposal was met with considerable resistance from various technical stakeholders who fear that engaging explicitly with such matters would create obstacles to innovation, as well as to the connectivity and interoperability between regions of the world with different human rights standards. So the bottom line is standardization bodies might be uninclined to address fundamental rights concerns stemming from AI technologies, especially issues that cannot be easily reduced to a product safety language, right? Hence filtering out this fundamental rights protection concern that I mentioned before. So I'll close here with one line. The one line is this: product safety is an important element of AI governance under the currently proposed EU regulation. But it is not a key, in my view, for the protection of fundamental rights. Using product safety to promote fundamental rights risks backfiring, and it might be a better idea to think of fundamental rights protection under a dedicated instrument rather than trying to expand the preference function of product safety bodies, which are not really on the demand side for an expansion of their mandates as currently proposed by the AI Act. Thanks for your attention.
Thank you very much, Professor Petit. Very interesting approach. I'm very happy that we could combine Professor Keyou𝐠𝐤𝐿 and Professor Petit keynote speech. We had a sort of vertical snapshot on the two different approaches at US level, at EU level. Very interesting. And now it's time to pass to the round table and to ask Eleonora Faina to take the floor. Eleonora Faina is a general manager of Anitec-Assinform, that is an association that is part of the Confindustria system, mainly dealing with information, communication, technology, business corporations. Eleonora has a master in antitrust and market regulation. For over 15 years, she has been dealing with public policies and institutional affairs for trade association companies in the regulated sectors in Italy and Brussels. Please, Eleonora, take the floor. We are very interested to understand the Confindustria corporations, employers organization viewpoints on these topics. And I'm happy also to ask you, and later I will ask to Stefan and to Dua if we can connect your approach to the regulation at the transatlantic level, because we all know that it is open a sort of dialogue, institutional dialogue between US and EU also on this topic. Please, Eleonora, take the floor. Thank you again for joining us.
Hello, Michele. Hello, everyone. Thank you for the invitation. I also thank President 𝗏𝗏 for inviting us to be part of this panel. I really appreciate all the introductions that the previous speakers have done, and I found out some point of contact or reflections we had in the last month regarding the new AI Act. First of all, I want to say that we actively participated to all the process till now that is now in discussion in the EU level. We did it through our federation, European Federation, which is Europe, and through Confindustria bodies, trying to find out to have a balance between the needs of software provider, as we represent all the ICT industry based in Italy, and included some US company that were previously mentioned. And we are trying to find out also some consider which are the main focus for Italy application of AI Act. In our association, we are trying to find out which is the balance between support to innovation that we have to have as a European level and in national level, and the need also to cope with rights protection and to have an inclusive, social, respectful of fundamental rights for citizens at when considering AI and its application. What we find very hard is to have a correct consideration reflection, which is the best action that the European Commission can do when it comes to regulate something that is in constant evolution. Because what we appreciated by the previous relations, that there is nothing fixed, there's nothing major in a certain sense. So AI is something that's evolving day by day, and also the implication on which are the application of AI can change considering different sector, different players, different countries at all. And when it comes to protection, different member states has different sensitiveness considering protection fundamental rights. They are reflecting now in a discussion in the Council and the Parliament, which are very, very strong. That's why the two parliamentary commissions that are in this are in industry and 𝗏𝗏𝗏𝗏, so rights and justice commissions and industry commissions, which are in two messages, our main consideration. First of all, trying to focus that we cannot really pretend to focus on algorithms, trying to control all the algorithms. The quality of data and the nature of artificial intelligence is by far something that is changing quickly and in a rapid way. The point is that AI is fundamental nowadays for quality services, tailor-made services for citizens. So first of all, it's not to focus too much on how the functioning of algorithm is impacting, because it's not easy at all to have a regulation that can proactively and efficiently control algorithm by its functioning, as composing in the 2 or 3 big companies that now are setting the standards. Secondly, the point is that how we use actually artificial intelligence and the balance of the relations between users and producers of AI is something very hard to fix. That's why the discussion now are focused on trying to, have a value chain of AI that could be a little bit balanced, and trying to focus on which are the most important and relevant facts that the Commission is addressing. So, which are the impact of using AI currently or currently considering fundamental rights. Third, how we can effectively contrast or fight some unfair and unlawful application of AI. And when it comes to the role of, for example, the courts that was previously mentioned by 𝗏𝗏𝗏𝗂𝐿, what we say is that be careful that there is not very a broad, complete, and sufficient knowledge of what AI can do when it comes to legislative bodies or when it comes to the judicial bodies. So the impact is not that easy to for these companies, for these bodies to deal with. When I add one more comment is that the AI is something very useful for smaller and medium enterprises. They're very unprepared to focus with a large and burden administrative burden or legislative burden. So what we have to avoid is to build a system that's pushing out from AI application and use the companies that much need to use that. So if we are working on, as you mentioned before, Michele, in your introduction, on the different way of regulating of the US and EU, what we want to avoid is that to have like a very huge and complex legislative body framework that will impact mainly SMEs and the consumer at the very end. So what we want to have, what we would like to have is to have a light framework that could be flexible, not rigid. That's why in the discussion in the Parliament and discussion in the Council, they're now much more relaxed on indicating in the annex which are the risky and non-risky AI type. That because it's not easy to block them, and on the contrary, we can prevent innovation to exploit at the maximum. That is what is the mainly need for European companies and for Italians as well. That's why we supported in the contrary the action on sandboxes, which we consider is the area to allow startups and ecosystem of innovation and general purpose to exploit some more knowledge, what we can actively do with AI to support the productivity, to support the growth and development of our companies. Of course, there are some black areas when it comes to fundamental rights. That's why I agree with the 𝗏𝗏𝗏𝗏 when they say we cannot have a regulation that prevents totally the implication for fundamental rights. But it is why the digital ecosystem is working that way. We have tried with the GDPR to have a general framework for protection privacy, but it doesn't prevent to have some obstacles to a correct and framework, a correct application of GDPR, and to prevent any behaviors that contrast privacy violation. So first of all, we cannot expect to have a perfect world when AI Act would not impact on fundamental rights. And I come to the second question, when we come to the different approach from US and EU, first of all, we have to consider that the US is a leading champion of AI. So my first question is, I don't feel that the US is not sensitive for the violation of fundamental rights and so far, but I feel that they are very careful on how to rules the world when it comes to innovation and when it comes to AI, because the pros and contras could be not very easy to define. And when it comes to contrast, sometimes they are better to avoid some worse results that would impact innovation and exploitation for companies and for citizens as well. So in our main opinion, we are not contrary to have a general legislation, have some key milestones, but we feel that the action of the Commission is now, I mean, a little bit tempered by the intervention when it comes to there are some definitions that are already available. When it comes to AI definitions, there were something that were already available by the OCSE. So when it comes in member states and between the two main blocks, I feel that to have a common approach on AI, we should have a discussion at a global level, at least a transatlantic level. That's why we supported the restart of negotiations with the US when it comes to AI and, generally speaking, to all the legislation impacting the digital services and digital economy, because it's not possible to have a European bubble area when AI acts in a different way when it acts in the US and in China and somewhere else. We should have to have a common approach on standards. And in the very first relations where some consideration standards, I feel that there is a point just to have a discussion at global level on standards. The two areas of the world are more competitive in this sense that we are in EU and US, are now trying to set a common approach on AI regulation, and I feel that the engagement of the US in this sense is very positive. But what I fear so much is that the EU will have a common approach on regulate, and then we'll see what will happen. And what will happen is not to avoid to have an EU that will lag on innovation and investments. That is one of our main fear. Because our companies, SMEs, for example, has a very huge need to invest in AI. And generally speaking, there are some points on definition, some point of methods, and I feel that the discussion now is moving in the good way to reduce the impact of too heavy regulation AI. I feel that how we will implement the AI Act will be decisive for the success of the regulation. Otherwise, we will risk to have another lost occasion to support innovation in the EU. Thanks so much.
Thank you very much, Eleonora. It's very interesting what you said. We got that in this field, more than others, regulation should be tailored in order to balance opposing interests, but also to take into account the impacts of the rules on the market and on the global market, as you said, on the value chain and on the competition arising from the different jurisdictions, Europe, US, Asia, and so on. I also got that the legal system should not renounce regulating technology and surrender to market forces, let's say that, but rather it should pick the desired gifts of the market in a fully coherent way with its own policies and the desired social objectives. And on the basis of that, I'm very happy to introduce Stefan Grant. He is a senior advisor at the European Trade Union Confederation. His main areas of work are workers' participation and digitalization. Currently, he's focused on the regulation of artificial intelligence. Before joining the European Trade Union Confederation, he headed the Brussels office of the German Trade Union Confederation, the 𝗃𝗵𝗫, and he studies economics and politics in Hamburg, getting a MA on these topics. I'm happy to introduce Stefan because as a labor law scholar, along with Silvia, with Professor Treu, I mean, we are very interested to understand the position of the European Trade Union on these topics, because we are keen to understand to what extent the collective bargaining and the social law can in some way interlock with all these EU legislation, not only related to the protection of the workers' rights, but also to I mean, in the vision, in the perspective to create more occupability, more chance to enter labor market and to have a sort of upskilling, reskilling of workers in order to face with the challenge arising from artificial intelligence. In addition, I want to stress, and I hope that Stefan can mention it, in June 2020, the European Trade Union Confederation, along with the most significant European employers organization umbrellas, decide to sign, in my view, a very interesting and very future-crafting agreement concerning artificial intelligence at plant level, where the principle is not to fix the rights at all, but is to balance the labor rights with the innovation and the investments. And the key words of this frame agreement is procedimentalization by means of social dialogue, examination, information, and consultation procedures. So thank you very much, Stefan, for joining us, and thank you to European trade unions for having accepted our invitation. Please take the floor, please.
Yeah, thank you, and also hello from Brussels. Thank you to having me there. Yeah, let me maybe start a little bit about our approach, and I think the basic issue you always have in mind is, of course, and that is something very easy to say, technology is neither bad or good, but you can use it, of course, for both sides. And that makes it, of course, very important that we regulate it right. And if everything what I have heard right, that AI is actually more or less revolutionize how we live, how we work, then it should be maybe good to regulate it and make sure that it only can be used for the good and for the gains, and that it helps us to society and how we live to develop it further to a better level and not to it worse. And there, of course, the AI Act is an important piece of legislation for us, even though we expected more, to be honest, as trade union movement, but I might come there a little bit more. I think I don't have to say any much more on the dangers of AI, because I think Sonja, she really was a very good presentation, and she raised actually all the questions and all the dangers we also as a trade union movement see if it comes to bias, discrimination, and so on, especially if it comes to the application of AI in the workplace, if it comes to hiring, firing, and promotion. But we see a little bit the problem with the AI Act is, first of all, the Commission chose the risk-based approach, but it's such not bad, but it's a new legislative framework. However, this framework was never to be designed, to be honest, also to regulate the use of a product. It is always designed as a product safety legislation, so to make sure a product doesn't harm. What is, of course, if you have a physical product like these headphones, easy, huh? You have to make standards that I don't get electric shock, that I can't strangle myself here with this cable, and then you put the standard, and then the producer have to tick the box and have to notify that he comply with the standard, and then he can put it to the market. No, AI is not just a normal product, because first of all, as we have heard here before, the harm is not always material. material harm. It is immaterial harm. A lot is discrimination and other issues, but it's not so easy to fix via standard. I think there was what Nicolas Petit actually quite interesting also said on it. It is a bit problematic to have these individual rights or these fundamental rights put in the standard, but all the critics we have also in the trade union movement, of course, of these standardization procedures, where trade union civil societies, for instance, have only a minority influence at all. And to be honest, if it comes to fundamental right protection, it should be always the legislator to set the standard and not some private standardization organization. So there we see already the problem we have in the AI Act. Maybe I can also say about what is actually what we want to solve in it. What we see at the moment is that we can, with what is on the table, we can actually make a little bit of damage control. We have also a problem on the legal base with its single market, its product safety legislation. There's choose the legal base actually, which even rules out that you can regulate anything on the employment field in it. Even though it is for us, of course, the question how can we use it. What we see now is what we want to make sure that we not get in danger with national regulation, because as we have a full harmonization on a product safety directive, more or less, but also regulate the use, as I said, and not only to bringing a product on the market. We see that there could be the danger that it even prohibits further going national regulation, especially if it comes to the workplace, that it could be in contradiction to EU law. So what we actually try now to make sure that we get it through the legislative procedure is that we make sure in the regulation that employment law at national level is not affected. And of course, maybe something like we have in the GDPR, the famous Article 88 of the GDPR, where we have a kind of opening clause that member states can go further in regulation if they want to protect the workplace, health and safety regulations, and so on. So that we have there also some kind of opening clause and not see later on that the EGJ, that the Court of Justice maybe have their problematic with national law. That is what we want to get in. Of course, we want to have everything, every application of AI, what affects the employee relationship should be seen as a high-risk application. And that is much more than only hiring, firing, and promotion. So there we want to have a broader implementation of that in the AI Act. And of course, if it then later comes to all these procedures, and I think that we have also discussed already, we see a self-assessment is not sufficient enough for high risk. If something is high risk, then there should be at least, even though that doesn't solve all the problems, but at least a third-party assessment of such applications to see if that really comply with all the standards and things we want to see if such a thing comes on the market. Why it is important to have a regulation, I think in the workplace, many have been said, but maybe I will bring also a kind short of example from real life, actually from today. And that is maybe also show also to the colleague from Confindustria, from the employer side, why it might be also important for small and medium-sized companies. I have a very personal example, for instance. My husband has here in Brussels 2 restaurants, and one day he didn't get a new contract from a multinational, for a new energy contract. It's a multinational company operating here in Belgium, and from one day of the other he couldn't prolong his contract, and he didn't know why. Because there was never an unpaid bill, he has no much debt on the company, so there couldn't be any explanation why. And you try to call the call center, and after it felt like 1,000 calls, finally you got an answer. And simply it was because of one of these big credit companies who are doing all the credit rating for the banks, for big multinationals. They're rating everything, customers, private persons, like companies, like everything. They had somehow, and no one could explain why, a bad rating. And that's why he didn't get the contract. It was totally untransparency. It was a long time that he even found out what was the cause, and only because he was very hard calling and asking for it. And then it is even hard for him to change this private company who's doing this credit rating on some kind of algorithm or whatever. So there we see already also the danger, not only for workers or for consumers, also for companies, especially small companies who don't have a big legal department who can maybe then sue these companies to change their rating. So there we see it very, very day by day, even nowadays, and it's not in the future, what can be happen if you don't regulate AI and the use of such systems properly to avoid such thing. And there's of course transparency key, and there maybe are coming also to the framework agreement we reached here with the European Employers Federation on digitalization. AI was one part, to be honest, in this agreement, only a very small part. It was more on other forms of digitalization, but this AI part was also in there for us, and that is also kind of demand. If it comes now to the AI Act, we demand actually further legislation. We would like to see a directive on AI in the workplace. So where we really, under the social chapter of the treaties, regulate what we have to do when we have used an AI application in the workplace, especially when employee relationships are concerned. And there's, of course, the question of employee data protection key. There is, of course, the question of transparency, algorithmic management. There we have already now actually quite good, even though not perfect, proposal in the platform work directive, where we have a chapter on algorithmic management, where we exactly say how it is that there's a transparency, that the workers' representatives and the workers have can ask, actually the employer has to give them and show them how the algorithm works. And then, of course, we can come to information consultation procedure and even negotiations, either in collective agreements or in company agreements. But we have, for instance, I just read the company agreement on AI from IBM. But we have in Germany, there is a company agreement on the use of AI in the company of IBM. So these kind of things we can then do collective bargaining, or even at the company if it comes to company agreements. But for that, of course, we need also the rights. And that is, for instance, something where we have in some countries quite far-reaching information consultation and participation rights, but of course not in all member states. And there we would like to see here something in as I said, in a directive on AI in the workplace, where we exactly that what we have now also in the platform work directive, get some rights also to negotiate and have information consultation there. And there maybe I can put a little bit the bridge to the US, because I saw the impressive also in Sonia's presentation about what has been there as a draft laws or in the discussion, but I missed one, to be honest, and especially if you come from California. And we just had an interesting exchange with our colleagues from US on the Workplace Technology Accountability Act, what just brought into in the Californian Assembly by his member Ash Kalra. And there is especially there also discussion also in the US how to regulate AI if it's used in the company at the workplace, especially if it comes to the employees relationship. And I think that's very interesting actually to read what is in there, even though for us as European trade unions, we'll be missing a little bit the information consultation participation part of trade unions and the workers' representatives, but that might be a problem because of the US system concerning these issues. But it is interesting that there are also in the US, especially in California, discussion starting in this direction. And so there is actually not such a big gap. And let me close maybe my intervention just also with the two approaches we have. I think we are very proud in Europe of a precarious principle, and I'm also a big fan of this. So I'm asking me sometimes why we should give up it, and have sometimes the feeling the employers, they want actually both from both sides of the Atlantic. I think in on the US, you have more the principle, bring something on the market, but if it doesn't work and you harm someone, then I can sue you to death. that is not what we have in Europe, as I said. Here you bring something on the market if everything is tested. And if you comply with all these areas, then you also don't have to fear too high fees, or if something goes wrong, that it can even threaten your company, the life of the company. That is a different system in the US. And I have sometimes the feeling they would like to have the one thing from the US side, bring something fast on the market, but only the fines from Europe, that nothing can happen if something goes wrong. And I think that is not working. You have to decide what you want from both sides. That's maybe just as an impression from my side.
Thank you very much, Stefan. It was a pleasure to hear you and your position. And now in this sort of European social dialogue, I'm very happy to ask Mr. 𝗃𝐿𝐿 to take the floor. Mr. 𝗃𝐤𝐿𝐿 is advisor for artificial intelligence and in the European Commission Directorate General for Communications Networks, Content and Technology, focusing on international aspects. He has been strongly involved in developing the Commission activities in artificial intelligence and robotics, and he led a unit which was instrumental in developing the EU AI strategy, as first published in the Communication on Artificial Intelligence for Europe. I'm happy to have Mr. 𝗃𝐿𝐿 here because we can, first of all, understand the viewpoint of the European Commission, of European institutions on this topic, and as a second part of his speech, and is the last slot of our roundtable, also what we are going to do with the European, as European Union, with US institution on this topic. So please, Mr. 𝗃𝐿𝐿, take the floor. We are very happy that you are here, and thanks again for joining us.
Thank you very much indeed. I hope you can hear me and see me.
Yes, please. Yeah, everything is okay.
Great, thank you. Buongiorno, grazie mille per l'invito. È veramente un grande piacere, un onore presentarvi il punto di vista della Commissione europea. So I will make some comments, observations, and points which to some extent relate to the previous speakers, and to some extent also then bring perhaps other aspects as you outlined. So maybe I would like to just very gently disagree with some of the statements that were made at the very beginning. The statement that the US leads in technology and the EU in regulation, I would slightly disagree with that, because I think that it's often forgotten and assumed that AI is developed entirely in the US, which is not the case. In fact, in the EU, we have very strong AI research. If you just think of the fact that most big tech companies have actually set up research labs, research centers in Europe, it's harder to find one which has not done so. I think that testifies to the excellence in Europe in this regard. We are also strong in robotics. Why do I mention robotics in this context? I think it's important to understand that AI-powered robotics is a very big area of application for AI technology. I sometimes refer to it as two sides of the same coin. And this is an area, particularly this kind of sophisticated AI-powered robotics is an area where Europe is very strong indeed. I would also like to highlight the fact that we have a very strong business-to-business sector in Europe in this area, A lot of the discussion is related to the consumer-oriented companies which are active in this space, which of course are in the US. We also do, in fact, invest quite significantly in AI. So although the private investment numbers are not as impressive as they are in the US or in some parts of Asia, particularly China, public investment is nothing to be ashamed of. The European Commission is also a funding agency, and we invest in AI to the tune of 1 billion euros per year, and we have the longer term goal of investing 20 billion euros in the EU, public and private combined, by the end of this decade. So indeed, we are doing quite a bit in this regard. Moving on from that, taking the second part of that statement, the EU leads in regulation. I think we've heard very good arguments in the keynote speeches why this is actually a good thing. So we do think that we have to do AI in a way that is right for Europeans. We do think this technology has great potential. It can actually bring great benefits to our citizens, our societies, and our businesses. But we have to make sure that we deal with the risks, and there are risks, as has been highlighted very, very clearly. This is why we have introduced the AI Act. We think that this is the right way. We have been asked to deal with this technology already quite some time ago. We have, of course, been preparing the work starting from the AI strategy in 2018, and the background work obviously goes back many years before. So we do see the need to do something about this. There is one aspect to this which has not been mentioned here, which is, however, quite important, which is the aspect of fragmentation. So we wanted to avoid fragmentation, the fragmentation of the regulatory landscape in the EU by means of this AI Act. We did not want to have a situation where there are 27 different types of legislation in the Union. So we felt that it was important to have uniform legislation in place. But it also has then this aspect, the single market aspect. So we wanted to make sure that we have the single market functioning well also for AI products and different types of AI systems. So this fragmentation argument is twofold, and we felt that both of these aspects are very important. Now, one key aspect here is, in fact, to achieve the right balance, to strike the right balance between innovation and protection. And for us, this goal of protecting the safety and fundamental rights is obviously very, very important. But we still want to have an ecosystem of innovation which works and which produces AI systems which are beneficial. So we prefer to have the excellence and the know-how in Europe, and we want to maintain it in Europe. So therefore, we think that this kind of right balance between innovation and protection is needed and essential, so that we can also have development the development of AI products and systems in Europe, have the know-how, because that way those who control the technology can also control perhaps the access to it or the price to it. And there are, of course, I mean, various aspects of the AI Act have already been highlighted. There is this aspect of the conformity assessment being a self-declaration in most cases. That is one aspect which takes into account the burden and tries to minimize the burden on companies. There are also innovation favoring measures like the sandboxes, which were mentioned. So we feel that there is this need to also keep in mind and have the right balance between the different kinds of goals here. Overall, we actually think, that's an estimate, of course, it cannot be more than that, that maybe 80–85% of the uses of AI are such that they do not require any further measures, any further intervention from the regulatory perspective. Now, maybe just one detail about the AI Act, which has not been, or two quick details about the AI Act, which have not been mentioned, that I would perhaps like to highlight here, is that the high-risk applications, they cover two main kinds of uses. So on the one hand, it's the safety components of already regulated products. And these are, because of existing legislation, they are already subject to a third-party assessment. So here the conformity assessment would be done by a third party. We're talking about, for example, medical devices here or machinery. And then there are AI systems. They can be standalone, but can also be embedded where the AI system is, or the AI component is not a safety component in a regulated product. And there are 8 uses, 8 fields where we think that they constitute high risk. And those are the biometric identification, categorization of natural persons, the management and operation of critical infrastructure, education and vocational training, employment and workers management and access to self-employment, access to essential private services and public services and benefits, law enforcement, migration, asylum and border control management, and administration of justice and democratic processes. And maybe just on the types of requirements, they concern data, so training, validation and testing of data, traceability and auditability. There are transparency requirements and the requirements on the provision of information. There is the need to ensure human oversight and also to ensure robustness, accuracy, and cybersecurity. And of course, the providers have to have then risk management processes in place. Now, maybe I'll move from there then to the transatlantic dimension. So I would like to first point out, and as Professor Kārtial already pointed out, there is legislation in the US which is close to this area, which is kind of relevant. But I would also like to point out that in the US, there is existing legislation at the state level or at the local level. So in a way, the US and the light regulatory touch, if you like, may be changing. And a lot of that regulation in the US is going in a very similar direction to what the AI Act proposes. For example, the city of New York has introduced a bill to regulate the use of AI in hiring, and then the state of Maine, for example, has regulation on the use of biometric identification. One further aspect here is that the US is currently developing a so-called AI Bill of Rights. So this is a new initiative, relatively new initiative. It was started in the autumn, and we see that that goes in some ways in a similar direction to what we have been doing here in the European Union. And so it seeks to ensure certain rights for citizens, for individuals in this new digital world. Now, we have, as the most conspicuous, the most visible sort of sign of our activity and cooperation with the US is the Trade and Technology Council. And these are discussions with the US. It consists of 10 working groups, and there we have discussions about cooperation and convergence on a number of areas. And one of the topics that is discussed here is, in fact, artificial intelligence. From our perspective in the European Commission, in general, our international activity is aimed at ensuring ambitious global norms and cooperation frameworks in line with the rules-based multilateral system and the kinds of values that are important to us. So we also want to ensure, and this is also part of the goal of the AI Act, a level playing field globally for trustworthy and ethical use of AI. We want to be an active player in promoting good governance of AI globally. Now, of course, this transatlantic cooperation is particularly important because of the leadership of the EU and the US in digital economy. And this cooperation can then provide the foundation for we think, for new set of global digital rules, which balance the free markets and personal liberties and rights. So that's why we are therefore engaged with the US, and there are a number of work areas which have been defined for this work. Some of them have been touched on, not from this perspective, but have cropped up in the previous contributions. But we want to firstly operationalize some of the principles underlying the AI frameworks. So both of us, first of all, have endorsed the OECD recommendation for AI. The OECD recommendation, the OECD principles are very similar to the key requirements, ethical requirements that the high-level expert group that Professor 𝗏𝗏 was part of issued in 2019. The work was actually done concurrently, and the outcome is actually quite similar. Of course, the high-level expert group work, the ethics guidelines for trustworthy AI and the key requirements have largely inspired the AI Act. So, but we want to look at how perhaps these principles could be operationalized better. We are looking at AI risk management and evaluation measurement tools for AI. This is work that is conducted together with NIST. And here we think, so this is the National Institute for Standards and Technology, Standards and Technology. And here, indeed, we think that there is a common interest because we need to be able to understand better what we talk about when we talk about, for example, bias. So to understand the characteristics, technical and social-technical characteristics, like bias, robustness on the one hand, and social-technical characteristics like safety. And we see that this kind of work would be very useful and valuable in supporting standardization work and the work of the standardization organizations. As was already mentioned, the AI Act will be implemented by means of standards, which will be developed by the European standardization organizations. But obviously, we think that there is mutual benefit, and as was also mentioned earlier, having a common understanding here is very, very useful. Now, of course, each party, the US and the EU, will have full regulatory autonomy in their respective jurisdictions. So we will not aim to harmonize our legislation in this regard. It is up to the US to decide what they want to do with their regulation at the federal level, if they want to engage with it and how they go about it. Even if it might be desirable, as we pointed out, that there was a uniform approach, but at least we can agree on the technological base, if you like. And of course, our AI Act is not part of these negotiations. It's not subject to compromise following the negotiations. But we think that there is a lot to be gained here to understand bits better the concept, to also perhaps develop a hub or repository of metrics and methodologies for measuring AI trustworthiness and AI risks. And we want to see then what kind of risk management, whether we could have compatible risk management systems. In addition to that, we are also looking at, there is a study being prepared on the impact of AI on the workforce. So this is carried out jointly by the EU and the US, the Council of Economic Advisors on the US side and the European Commission, to see how how this technology then impacts, with 2 case studies, one on the recruitment services and the other on logistics and warehousing. We're also looking at the potential of privacy-enhancing technologies and to see if there could be a possible joint project there. And we are also looking at then to have a common understanding on social scoring systems, social credit systems. So these systems, basically, we have stated our opposition to them already in the first official statement from the Trade and Technology Council, which was published after the Pittsburgh summit at the end of September last year. But we want to understand better how this works. And of course, the AI Act prohibits general purpose social scoring by public authorities. So these are the work areas where we're trying to see convergence and cooperation and see how we can take things forward here. Maybe as a final point to conclude, I should add that both the EU and the US have subscribed to the risk-based approach. So this was also stated already after the Pittsburgh summit. So the US has also signed up to this risk-based approach to AI, so that any measures related to it should be related to AI should be proportional to risk. So obviously this risk-based approach, as has been already pointed out many times, underlies and underpins the EU AI Act. Thank you very much indeed.
Thank you very much. Thank you very much, 𝐾𝐤𝐵, for your speech. I'm really sorry. Maybe there was a misunderstanding. At the beginning, I say that there is this motto, but I'm not convinced that it's true. I mean, I'm trying to pursue the idea that the leadership in tech and regulation should be of the West legal system, and that I believe are US, EU together. The problem that we are facing all together, and we share this idea, I'm quite sure after this long morning, is that we should avoid in any way a tech chilling effect and the increasing of cost and an impact on occupability for the future in Europe and US. But we should create, this is my personal view, a sort of international cascade effect. If we will be able to better regulate this topic at US level, transatlantic level, maybe we can have a sort of reshaping of the regulation worldwide and having a sort of leadership in the regulation for the future. Thank you again for your speech. Thank you for joining us. And now it's time to leave the floor to Anna Maria Simonazzi. She's an economist, professor of Sapienza University and of counsel here at CNEL. It's hard work, your work, Anna Maria, to wrap up everything, all the things and the information and the topics that we focused this morning. Thank you again for having accepted this hard job, and please take the floor.
Well, thank you, Michele, and thank you all of you. But I mean, it has been a very interesting and fruitful workshop, and it is very hard for me to summarize, so I'm not going to summarize the main content of this workshop. Well, I think that I've been listening to you with with high interest, because artificial intelligence is a relatively new phenomenon, but it is speeding up at the speed of light, and regulation is catching up or trying to catch up, as it has always been the case in finance, in environment. So I think that we are still perhaps in a sort of work in progress. And I will only mention just a few points that have struck me. The first point is that we should try to avoid, perhaps, as much as we can, the trade-off between efficiency, innovation, and justice or democracy, both at the individual, at the collective, and the social level. So the first talk by Sonia Katial, and perhaps also the observation of Juha Heikkilä, forgive me my pronunciation, on the problem of how to control algorithms. And here the problem is, who is going to design these algorithms? What are the targets, the objectives of these algorithms, and how should we try to control them and to devise a way in which we can perhaps move them in the direction of justice rather than of exploitation. And one point which I thought it was very important is the use of data. This was a problem also before the artificial intelligence came to the fore, but with the use of algorithms, this is becoming more and more important. So not only the control of algorithms, but also the control of the data sources, and at the end, how to use all these results. This, I think, is a very important point. And the second then is how to regulate, which was the point raised by Nicole Petit. And here we have the problem of the pervasiveness of the artificial intelligence issue, the general purpose technology. So how can we reach all the innumerable rivals, ends in which artificial intelligence is used? So how do we ensure compliance? Should we rely on the users? Because as it has been mentioned, it pervades every kind of industry. And so we have in a multiplication of risks in each industry. And this is, I think, a very, very serious challenge. And one issue that I also was interested in is the commensurability of risk. How much risk? And this, I think, is a problem for harmonization of regulation across countries, across institutions, because perhaps the perception of the risk, the sensitivity to the risk can differ across countries and across institutions. And there is a problem of harmonization. For instance, all the problems of the risk at the workplace. Maybe we have different sensitivities if we move from the European Union to the United States, to China, or other countries. And so this might be a problem of finding the right degree of harmonization. And the last point which I would like to remind here is the issue of the competition in regulation, which was raised, for instance, by Eleonora Fana, but was touched also by the others. We should be careful to the risk of using regulation as a competitive issue. But there is also the problem of how to avoid the spillover effects of regulation or lack of regulation on other countries. And here is the risk of the social rights, for instance, the case of the use of artificial intelligence in the Philippines or in other countries. So I think that the European Artificial Intelligence Act is and the regulations that the United States are taking are important steps. They are first steps. We are, I think, learning how to make efficiency, innovations, and rights, try to coordinate and cooperate. and use at the best the artificial intelligence. But from what you have said, I think we have still quite a long road to cover. Well, I thank you very, very much for your insights, and I will leave it to here. Thank you.
Thank you again. Thank you, Anna. Thank you again to you all. It was a special morning for us. And thank you again from all of us from CNEL. This is a further occasion to show that this institution, CNEL, and along with the University of Rome and the Università Cattolica, is pushing for further investigations in difficult matters and complex matters, and also to try to understand if there is a fair path for justice and for the future. Thank you again to you all, and looking forward to hugging you all here in Rome or wherever we can meet. Bye. Thank you.
Thank you. Bye.
Thank you.